The jury in this case is being transported from a different location in a bus with the windows covered so that they don't have to look at aren't exposed to any signs by one side or another or interest in the case. And so I'm going to call it a sealed bus. And that's been done every day, and then they're brought here to this building. And last evening, a person who identified himself as James G. Morrison and who claimed that he was a producer with NBC News, employed for MSNBC. The police, when they stopped him because he was following at a distance of about a block and went through a red light, pulled him over and inquired of him what was going on, and he gave that information and stated that he had been instructed by Ms. Bayan in New York to follow the jury bus. The matter is under further investigation at this point, and the media has asked questions about it. That's the latest I have. And he was ticketed for violating a traffic control signal. He's not here today from what I'm told, and I have instructed that no one from MSNBC News will be permitted in this building for the duration of this trial.
Welcome back to Court TV Live. I'm Julie Grant. That incident that the judge was just describing brings to the forefront a very important issue about whether our American justice system can survive if juries are not kept free from outside influence. Now, to discuss what the Constitution says about this issue, we are calling on the very best constitutional law expert, Harvard Law Professor Emeritus Alan Dershowitz. Professor, welcome to Court TV Live. Always great to have you joining us. If I may, please, I'd like to begin with that incident with the producer who was working for MSNBC. What did you think when you heard this, please?
Well, I worry that the jury may think that they are being followed and that their identity will be released and that they will be subject to the kind of threats and intimidations that have been suggested in other such cases. I just want everybody to imagine, as neutral, objective, civil libertarians, if the shoe were on the other foot. You don't have to imagine it. Go back to the 1920s. You get trials in the South where black people are put on trial for killing white people. And imagine if a bunch of white ministers surrounded the courthouse or were in the courtroom praying for a conviction. That I don't think would be acceptable to many of us. I was in a case once back in the 1960s early 70s, where a group of people came into the courtroom and prayed for my defendants. It was the Jewish Defense League defendants, and the judge banned them. Said, no, there's no room for prayer, open prayer in a courtroom. Courtrooms are for justice. And, if you want to have a minister sitting next to the relative of somebody to give them comfort, that's one thing. But when you have ministers and others advocating a result and praying to God for justice, which means conviction, I think it raises fundamental constitutional questions under Shepard versus Maxwell and other Supreme Court decisions, the Scottsboro case, the Leo Frank case. Courts have to be scrupulous in avoiding the thumb, in this case the elbow, of the mob being on the scales of justice.
Absolutely, Professor. There is Dr. Sam Shepard there. We're showing our audience at home this famous case that you referenced, Shepard versus Maxwell.
Yeah.
The initial case, I know you're familiar with this, Professor Dershowitz. Your colleague, F. Lee Bailey, as you know, was the one who took this all the way up to the U.S. Supreme Court. And it's still good law that essentially says that the trial court has a responsibility to ensure that the jury is kept insulated from outside influence, whether it's from members of the media or from members of the public. The jury deliberation process and throughout the trial, it's all sacrosanct. And in the Shepard case, I know, it was a media circus back in Cleveland. I mean, it truly was.
It was different. There it was a media circus because of the celebrity of the people. But there were people on all sides of that case. Here you have advocates. Here you have people praying for a result, asking God to intervene, and doing it in the courtroom and outside the courtroom. I think the Shepard case stands for the proposition that you can't let TV cameras in the courtroom, you can't turn it into a circus, but it wasn't so much about the scales of justice being tipped in favor of conviction by a group of people. And I think if the shoe were on the other foot, if this were, again, white ministers praying for the conviction of a black person charged with killing a white person, I think many of the media would have a very different approach to this. And I think you always have to ask the question, what if the shoe were on the other foot? Can you have neutral justice? You know, you can't have justice for one and not the other. For example, there are complaints that the lawyer talked about the reverends being black. Race is relevant in a case like this. If there had been only white people campaigning for the death of a black defendant, people would of course raise the issue that is white versus black. We lived in, tragically, a reality of a racial world and of a world where many people see everything through the prism of race, and suddenly to become purists and say, oh my God, you can't mention that the ministers are black, seems to be extremely hypocritical.
Professor Dershowitz, let's talk a little more in depth about what the solution ought to be, what our Constitution says about the issues
Sure.
we just heard argued this afternoon, right? We hear Kevin Goff motioning the court once again for a mistrial. And I thought what one of the other defense attorneys said, Attorney Hogue, said was really spot on, where he said, I have concerns that the jury is being influenced. What's the solution in your mind, please, Professor?
Several solutions. Number one, you always sequester juries in cases like this. You always sequester them. Number two, you move the trial. It shouldn't be in the place where the alleged crime was committed. You move it to a more general area, not to an area where jurors are going to be concerned that their homes are going to be destroyed. Number three, you postpone trial sometimes until the atmosphere is more conducive to being able to do justice. You just cannot let the crowd influence justice. I think the worst example of this now is the case of Officer Potter in Minneapolis. Officer Potter did nothing absolutely criminal, absolutely nothing. She pulled out the wrong gun by accident, and she shot and killed somebody instead of tasing that person. Terrible thing. She should be retrained, maybe fired, but it's not a crime and it's not murder. And yet the crowd has pressured the prosecutors into trying to escalate the crimes and make it into something that it isn't. And I think we're seeing the criminal justice system today being held hostage to the mob. We hated it when the mob was white and Klansmen and racists. We should hate it as much when the crowd are good people, decent people, people who are seeking racial justice. That has nothing to do with whether a given defendant in a given case is guilty beyond a reasonable doubt. And so we ought to apply the same standards to racists and to people who care deeply about racial equality. The law doesn't make that distinction.
Professor, for those at home wondering who may be shocked to hear what you just said about Officer Kim Potter and how it's your opinion she shouldn't be criminally charged, would you explain to us why? I know you've got a rationale why under the law you're saying that, but to many at home that might think, oh my gosh, there should be some responsibility, because how does she not know? She's got her duty weapon in her hand when she's firing it. How is she mistaking her firearm for her taser?
People make mistakes all the time under pressure, and there's no allegation or proof that she deliberately picked the gun and fired the gun. You see the videotape, she screams and yells, oh my God, used other words, I shot him, I shot him. It's so clear that it was a terrible, tragic mistake, a mistake that may impose civil liability and may require her to be retrained on the use of weapons. But in America, accidents are not crimes. Accidents are not crimes. You need mens rea. You need a deliberate intent to kill or recklessness. And in this case, I just don't see that being made. Look, I don't want to defend anybody in particular. I'm just saying the case has been influenced by the mob. Remember, the mob hasn't been satisfied that she has been charged with manslaughter. They want to charge her with murder in the first degree, as if it was a gangland killing. and they won't be satisfied. And, you get people like Maxine Waters, who basically threatens jurors and says, unless you give us the verdict we want, the highest possible verdict, there's going to be violence on the streets. And that's not the way the criminal justice system should operate. And it doesn't matter whether you're a liberal, conservative, white, or black. If it's bad today and it's directed at white people, it's going to be bad tomorrow and directed against black people. The rules don't distinguish based on race, and they don't even distinguish based on whether you're on the right side or the wrong side of a large political issue. The issue is the guilt or non-guilt of a particular defendant in a particular case, and every case should be handled with that in mind, not with the bigger picture of whether we achieve racial justice in this country through the courts. Criminal trials are not the mechanism for achieving racial justice.
And Professor, referencing there Maxine Waters and that issue, of course, that occurred during the Derek Chauvin trial in Minneapolis, Minnesota. I'm sure our viewers who watched carefully can harken back to that moment. And you came on the show at that time, and you were saying how that was really putting your thumb on the scale of justice. I believe those were your words, and you were saying this cannot happen. This cannot happen in America. And what is the answer? How can we prevent this? I mean, you outlined three great things: always sequester, always move the trial, always postpone the trial until the climate is a little better. But in terms of, let's say, like proximity of the protesters, for instance, in the Rittenhouse case, we know that our members of our Court TV field team can hear faintly chanting and the beat of a drum as they're in the courthouse and close to the jury room. So presumably the members of the jury can hear that faint beat of the drum and can hear the chanting. And is there any type of First Amendment violation you would see to set up a designated area for protesters that would be far enough away that members of the jury could not possibly hear it as they're thinking and discussing the case?
Yeah, the Supreme Court has said time, place, and manner restrictions that are neutral are constitutionally acceptable. So yes, you could require them to be far enough away so that they're not audible or visible to the jury. First Amendment rights should never be compromised. They have a right to protest. They do not have a right to try to influence the jury. They have a right to try to influence the law, change the law. They have a right to try to influence the governor, the legislature. The one group that the First Amendment does not allow you to try to influence is the jury. Felix Frankfurter, the Supreme Court opinion, said that. Others have said that. Oliver Wendell Holmes has said that. And that's the existing law. The First Amendment does not allow you to try to influence the outcome of a particular jury verdict. And that distinction has to be kept clearly in mind.
Professor, I want to ask you your thoughts on how after trials juror names are made public. And I'm wondering, in this day and age, is that a practice that you think we ought to be rethinking in America so that jurors aren't afraid of backlash down the road because of deciding the case one way or another?
I think that we should either have all juries anonymous or no juries anonymous. I think when you pick and choose and tell one jury, you're going to be anonymous, all the other jurors are not anonymous, you're telling them you ought to be scared. You ought to be frightened. This is a case that puts your safety at risk. So I would be happy with a rule that said that the names of all jurors shall be kept confidential and anonymous. There's a problem with that, too, because you do want members of the public. If members of the public say, oh, my God, John Smith's on that jury, don't they know that he's a racist or he's a this or he's a that? So there is some sacrifice that's being made. But I think anonymous juries are essential in certain cases. But when you limit them to certain cases, it sends a dangerous message. It started with mafia juries. And when a juror in New York discovered that they were anonymous, they said to themselves, oh, my God, is Gotti going to come and get me? Is this mafia guy going to come and get me? And they were scared. So we have to be sensitive to all the issues growing out of anonymous juries. But I think juries should generally be kept anonymous until at least sometime after the trial is over.
Professor Alan Dershowitz, this is all really, really helpful insight you're sharing with us. Would you kindly stay to do a little more in this segment? Because we'd love to ask you about whether you think the charging in some of these big high-profile cases has potentially been influenced by the mob on the outside.
I can I can stay a few more minutes, yes. Please.
Very good. Professor, thank you so much. We're going to squeeze in a break. We'll be right back with arguably the nation's leading expert in constitutional law, Professor Alan Dershowitz. You are watching Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host, and we are so pleased you're joining us on this Friday afternoon as the nation is watching two major trials in Brunswick, Georgia, the case of the three men accused of murdering jogger Ahmaud Arbery, and in Kenosha, Wisconsin, the case of defendant Kyle Rittenhouse. And we've got our jury deliberation clock ticking, 25 hours, 52 minutes and counting. This jury has been out. They have not indicated that they are deadlocked. What we're doing now is analyzing a big issue that's been brought to the forefront in our country, and that is, are juries truly free from outside influence? And if they're not, how can our system then function? We've called on the very best to talk about this. Joining us, Professor Emeritus at Harvard Law, Alan Dershowitz. Professor, where we left off, I was wanting to ask you about how in many of these high-profile cases we've seen, Kyle Rittenhouse, the Derek Chauvin case, Kim Potter. Do you think that district attorneys' offices are at all being influenced by the threat of mob violence in the charging and in the quick charging of these cases?
I have no doubt about that, not only by the threat of violence, but by the threat of not being reelected. They are following them up. You know, you have to remember, this is something that most Americans don't appreciate. We are the only country in the history of the Western world, categorically, the only country ever to elect prosecutors. It's a disaster that we have elected prosecutors. No other country in the world has it. Our prosecutors run not only for re-election, but virtually every member of the House and the Senate who are lawyers have been prosecutors. So being a prosecutor is a stepping stone toward higher elective office. And so prosecutors are far, far too influenced by not only the mob, but also by voters, and they shouldn't be. In every other country in the world, being a prosecutor is a civil service job. And decisions are made based on the law, not on popular appeal. So we have a real problem in this country, and it's become exacerbated, but merely exacerbated. It was always a problem. But it's become exacerbated by the threat of mob violence.
Professor, I couldn't agree more. And the cancel culture that we are seeing, and you make a great point that if elected officials are afraid of being canceled because of decisions that those who partake in mob threats, it really puts a thumb on the scale of justice, as you say, Professor. Tell me, in the Rittenhouse case, I would love to pick your brain on one of the issues that the defense team has cited in their motion for mistrial. And I know you are renowned in the United States for your criminal defense work, as well as your work as a professor. Tell me, with respect to the video, just the drone video that the defense is saying, hey, state of Wisconsin, you turned over to us a copy that is so resolution we can't see what is exactly happening. And when you kept the copy that is clear as day, and if we had that clear copy, it would have affected the way we would have fashioned our defense for Kyle Rittenhouse. Does that argument have teeth, Professor?
Very much so. If I were a criminal defense lawyer, I would be furious that I didn't get the same copy that the prosecutor got. Prosecutors don't get more and better evidence under the law than the defense attorneys do under Brady and other decisions. The amount of evidence, the quality of the evidence must be equal. And I completely agree that if you see a video and it's not clear, you decide to do something very different than if you see a video that's crystal clear. You may make a different decision depending on what witnesses you want to put on, expert witnesses about the quality of the tape, a range of other issues. So I think that they have a good appellate issue. I don't think this judge is going to grant a mistrial because he doesn't want to be the one who lets Rittenhouse go free. But a court of appeals a year from now, sitting away from Kenosha, might very well say this was a Brady violation that denied the defendant the right to a fair trial.
Right, Professor. Speaking of the judge presiding over the Rittenhouse case, last night many folks watching the trial were scratching their heads when a member of the jury asked to take home the jury instructions. And
Yeah.
the court said, sure, you may do that, just you may not discuss the case, as is the instruction every day throughout this process. What do you think of that? Is that proper?
I would have come out the other way on that. I don't think that jurors should be encouraged to deliberate independently. It's a collective effort. And I think it's far better to have jurors read the instructions in the presence of each other and not to take it home. And there's, of course, always the risk that, one of the jurors calls his uncle and says, hey, you're in law school. What do you think? So I think on balance, it was a mistake. I don't think it was a serious mistake, but I would have ruled the other way.
Sure. Could anything come back to haunt the judge with a decision like that, or would the error just be so harmless that, hey, look, if anything, this person's just getting a more clear picture of what the instructions contain?
Well, it could help on an argument that the instructions themselves were wrong. The instructions were wrong. They were not good instructions. There were two trials in Rittenhouse, completely different trials. The prosecutor put Rittenhouse on trial for being there, for having a gun, for being part of the demonstration. He should have stayed home. And the defense said, basically, it doesn't matter whether he was there or not. In the 2 or 3 minutes surrounding the shootings, his life was in danger. What if the jury believed both of those things? What if the jury believed he shouldn't have been there, he shouldn't have had a gun, it was wrong, he provoked it, it was his fault, but also he engaged in self-defense at the moment. The judge did not give a proper instruction on how to resolve that issue, number one. And number two, the prosecutor gave a dreadfully wrong closing argument when he said if you bring a gun, basically you lose your right of self-defense. Look at the Trayvon Martin case, where the defendant Zimmerman had a gun and Trayvon Martin didn't, but Trayvon Martin allegedly banged Zimmerman's head against the pavement over and over again, and the jury correctly in that case decided it was self-defense. So the law is clear. You can defend yourself against lethal or dangerous force even if there's no gun involved against you, and you can use a gun. So that was the wrong instruction. What shocked me is that the defense didn't object to it.
Right, Professor. So many things objectionable in that close and in rebuttal.
I have to run now, but I'm always happy to talk to you because your audience is always so interested and so interesting, and your commentators are always so good. So keep it up, and thanks.
Thank you kindly, Professor Alan Dershowitz. You take care, too. Speak soon. All right, and with that, we are going to squeeze in a quick break. We know that the attorneys are going to be back in Brunswick, Georgia, as they hash out the final instructions that the judge will give the jurors on Monday in the case of the 3 men accused of murdering jogger Ahmaud Arbery. And looking at the jury deliberation clock, we are just about to hit the 26-hour mark in the Kyle Rittenhouse case. We'll be right back.